Good morning, Mr. Robinson here. Starting a new unit today in civics and economics. The new unit is the court system. All right, so there are various different types of court system. All right. Today we're gonna look at the federal court system. So there's also a state court system. There's also a criminal court and civil court. All right, but some of them run together. Today, federal court system. All right, and I'm going to talk about it. The assignment is on Canvas. The assignment is very simple. So with the assignment, it's just definitions. All right, so I give you things to define, and you have to define them in your own words. Now, I don't want to see no copying and pasting where everybody has the same exact thing on there. All right, so I want to use your own words, and some of the definitions are on here on the slide that I'm gonna go over. So here, let's get into it. So the first thing about the federal court system, or just the court system in general, is something called jurisdiction. Jurisdiction is right what it says there, the ability to hear a case. It's like the power that the court system has over certain cases. You have something called original jurisdiction, which means the first time. The first time a case is presented, it's the original jurisdiction. Ability to hear and decide a case that it is heard the first time. All right, so if you hear the first time, you have something called original jurisdiction. Now, there's also something called appellate jurisdiction. So this happens when there's maybe a discrepancy in the case, or a person has the right to appeal the decision. So if, in other words, if someone is on trial and they get convicted of a crime, they still maintain their innocence, they can appeal that decision to a higher court. So that's what appellate jurisdiction is. Appellate jurisdiction does not hear the case the first time. They hear it. It's a higher court that hears it again in case there was a discrepancy in the case, or maybe there's some evidence left out. But the defendant has the right to appeal a case. So this is appellate jurisdiction. Concurrent jurisdiction. This is so we have a state court system and a federal court system. Concurrent jurisdiction is when the state court system or the federal court system can hear the case. Most of the time, most cases are heard in state courts. All right, make sure you know that for the test, but I'm going to be stressing that throughout the unit. But concurrent is when a state or federal courts can hear the case. Now, really what we're talking about today is federal jurisdiction. So, if there is a case where there's something that there's a law or something that the Constitution is written in the Constitution, then that is when federal jurisdiction plays a role. So, for instance, say if you look at like Brown versus Board of Education, where with the segregation of schools. So the people, the NAACP, which stands for National Association for the Advancement of Colored People, brought this case to court because they were protesting the segregation of schools because they said it went against the 14th Amendment, well, to the Constitution. So that involved the Constitution. So federal courts were going to hear that case, all right, and eventually went all the way up to the Supreme Court. So cases involving the Constitution. If it's a federal law, that is another jurisdiction that federal courts would hear the case. So a lot of federal laws again have to do with voting rights, or say, for instance, or the Constitution. But say, what's a federal law that's well known? I guess. Well, if you look at the the Equal Opportunity and Fair Housing Act, all right, this would be a case that's a federal law passed during the Civil Rights era. That would be if someone was saying, "Hey, they won't allow me to live in this neighborhood because the color of my skin." That would involve a federal law, and that would be part of federal jurisdiction. disputes between the states. So if this used to happen a lot in older times, or past times. So if North Carolina claims an area, a part of land, and then Georgia claims the same part of land, same area, that would go to a federal court, federal jurisdiction. So if two states have a quarrel with each other, it goes up to a federal court. Citizens from different states, same thing. If similar thing, if someone in North Carolina has a quarrel with someone in South Carolina, and the instance takes place in both states, then that would involve federal jurisdiction. Cases involving the federal government, foreign government treaties. So a couple more things. So say there is a kidnapping case, right? Someone is kidnapped in North Carolina and they are taken to Virginia. Okay, this is going to involve the federal government because they're crossing state lines. And so you would first you would get the FBI, or Federal Bureau of Investigation, involved, and then it would go to a federal court. So foreign government and treaties. This is again with treaties with foreign governments. That's not going to be heard in state courts because those are federal treaties or national treaties. And then admiralty and maritime law. So in basically the maritime means ocean. The ocean off our coast does not belong to a state. And if it's a United States citizen out there in the ocean and there's a case that needs to be heard, that would involve the federal government, federal jurisdiction, not state jurisdiction. Diplomats as well. So this is the level of federal jurisdiction. You need to know this, all right? These are the various levels. A district court, appellate court, Supreme Court. District court is where cases are heard the first time. Remember, original jurisdiction. All of them start, or 99.9% of them start in district court. And they have the original jurisdiction, only original. Appellate court. Remember, a decision can be appealed to a higher court. Appellate jurisdiction, appellate court. This is the second level. And then finally, if it keeps going and it involves a very strong constitutional issue, it will go to the Supreme Court. Remember, the Supreme Court, they interpret the Constitution. So that's kind of the final level of it, is the Supreme Court. This is the bit where the big dogs, where the big cases are heard. Here I go. District courts. Federal courts where lawsuits heard and trials are held. All cases, they must begin in federal court. So now it's the only place an actual trial, meaning an actual trial, you have a judge, jury, lawyer, defendant, you have all of that taking place. What you think of as a trial when you see TV in movies. There's an impartial jury in place, as well as a judge in place, as well as attorneys from both sides and a defendant. They decide guilt or acquittal at the district level. Now, an appellate court, appellate jurisdiction. So you have the Court of Appeals, U.S. Court of Appeals. Remember, this is federal, okay? We're going to study state courts later. They look at the decision of the lower court, the district court, and they look to see if the law has been upheld. In other words, was the defendant treated fairly? Was the decision a fair decision? Was all evidence that had come to light, was it reviewed? And those things. So they review the decisions of the lower court. So the only thing that happens, there's no jury. There's just the prosecution and defense attorneys in appellate court. 3 or more judges here. So there's no jury. You have 3 appellate court judges that hear the evidence. There are different appeals circuits throughout the country. Again, they can only hear appeals from their circuit. So in other words, I can't remember which one North Carolina's on. It's in the textbook. I think it may be the 3rd. I'll get back to you. I have to check that out. But in other words, if there's a case involved that originates in California, okay, that would not be on the appeals circuit for North Carolina, okay. So this is at the appeals court. This is what they can do. They can uphold the case or say, "Hey, look, ruling stays the same. The lower courts did a good job. We're just going to keep it the same." They can remand the case. The case goes back to the district court, send it back for a new trial. So it's kind of like, for instance, say you give a gift to someone for Christmas. So what they can do is they can uphold it or they can keep it. All right. Sometimes what they may do is they may take it back to the store and just get a new gift, get a receipt from the store for money that what the gift is worth. Or some people may just they don't like the gift at all and they don't want to take it back to the store. They may throw it away. So in that case, that would be overturning or reversing the decision that the lower court made. So those are the three things the appeals court can do. They announce the decision, and so they write an explanation of what they think. And basically, an explanation is, "Hey, this is why we chose what we chose." The majority is the winner. Majority opinion, what most of the judges think. So if you have three judges, it's going to take two to get a majority. This is the majority opinion, and this is basically the decision that is made at the appellate level as well as the Supreme Court level. All right, the dissenting opinion is the one that it's basically like it says the loser, and they again lay out their thinking that made them go decide against the majority opinion. So the dissenting opinion is the minority, essentially, of the judge's opinion. All right, precedent is important. So precedent is using a previous decision in a similar case to make a legal ruling. So a lot of times courts would do this. We'll say, "Hey, there was this case 10 years ago that was basically the same case or similar case, and we're going to use the decision in that case to make our decision in this case." All right. So the court systems use precedent. Now, a federal judge is important that you know this. They are appointed by the president, all of them. So not only Donald Trump recently appointed Amy Coney Barrett to the Supreme Court, and now they're going through the confirmation from the Senate. The Senate has to confirm her. But not only is the president appoint Supreme Court judges, they appoint all federal district and appellate court judges as well. So all federal judges are appointed by the president. Okay, and he doesn't. Now look, the president is a busy person. He or she doesn't just look at every single one of these. He has what's called the Department of Justice, those cabinet departments who help advise him on who to pick for or who to appoint for these various justice seats. They're all of them like same thing as the Supreme Court. It's a lifetime job. Once you get it, you're in the game for life. Now the Supreme Court. This is the final. This is the highest. All right. You have 9 judges. You have 8 associate judges and 1 chief judge. Appointed by the president, confirmed by the Senate, and they serve life terms. Same as with the all federal judges decide. Now this is a little different. They decide which cases to hear. So they look at all the cases and they decide the ones that are important with constitutional issues because they're the ones that are interpreting the Constitution, the Supreme Court judges. All right, so that's it. Now, look, hopefully, I know I explained most of those definitions to you right here through the video. You'll probably use the video here with the assignment I'm going to give you tomorrow. Okay, so if you have any questions about anything, please let me know and give me an email.